Hi, welcome to training for today. We'll be discussing provisional waivers. When and how can a provisional waiver be the key to solve a foreign national client's immigration status problems while living without any legal status in the United States? Stay tuned as this is the topic of training for our immigration lawyers and staff today. First, we need to determine the eligibility for a foreign national to be sponsored on a permanent or temporary visa. Once it's determined the individual is eligible to apply for a permanent visa to the United States, are there any obstacles or inadmissibility issues for the client? If yes, what is the obstacle? The obstacle here is entry into the United States without inspection, i.e. the foreign national is in the United States undocumented. The solution is a provisional waiver called I-601A, which may overcome this inadmissibility issue into the United States if the undocumented applicant meets the following requirements. Let's go through those requirements. Number one, in the U.S. at the time of filing the I-601A. Number two, the individual must be 17 years or older. Number three, the only inadmissibility issue is unlawful presence. So, there can be no criminal issues or misrepresentation or fraud issues, for instance. There is a way to deal with other admissibility issues which will not be discussed here. Number four, a case must be pending with the Department of State National Visa Center. The fees are paid and a receipt must be issued by National Visa Center as proof. Once you receive that proof, that helps to understand the next step, which is departing the United States to pick up U.S. permanent visa. That permanent visa is required once approved, and re-entry is mandatory in the correct way. Next, the extreme hardship to qualifying U.S. citizen or permanent resident is required for an approved waiver in this case. The qualifying U.S. citizen also, or the permanent resident whom would suffer a hardship, has become very broad and includes the U.S. citizen's spouse and parents and legal permanent resident spouses and parents. The underlying petitions include the Special Immigrant I-360, the Diversity Visa applicant, and the derivative family members, and the I-140 employment-based applications. Overstaying a visa is important to distinguish from entry without inspection of undocumented individuals. A waiver is not needed for someone who has overstayed a visa but came in legally. All right. We will now discuss the steps attorneys must use in preparing a strong I-601A waiver. The I-601A is filed with USCIS after the underlying petition I-130, I-140, or relevant underlying petition is approved by USCIS. You submit a legal memorandum with the underlying petition as well. Prepare the I-601A application and declarations with the underlying petition to ensure client will get through the entire application process. However, you only file the waiver after the underlying petition is approved. Concurrent filing is not allowed. Print off the I-601A instructions. That form is really important from the website, and verify the version before having the legal support staff prepare first draft of waiver forms. Request also a successful I-601A template file in the office where prior clients were approved, and use this template file as a guide while preparing new clients' I-601A waivers. Send clients the questionnaire addendum before the intake so they have time to think and prepare the essential hardship information that needs to be gathered and evidence needed. Evidence accepted and considered by the government for the waiver includes the following: expert opinion, medical documentation, country conditions, payroll records, educational considerations, future hardship situations, also such as employability, termination of a profession, mental health are all considered. And the length of time in the U.S. and significant ties is helpful. Next, the Department of State National Visa Center will eventually notify the applicant's lawyer, and applicant will have the opportunity to pay the fee in order to successfully have the I-601A received by the government. Well, that's it. Be sure to follow all the firm internal policy and quality check systems to ensure client's case is a success. Thank you.